Welcome to the deep dive. Today, we're wading into some pretty serious legal combat in New York. This isn't your typical case review. We're talking about an insurer suing the opposing lawyers, accusing them of, well, deceit and fraud. High stakes.
Absolutely. We're looking at a motion to dismiss and the opposition memo. It's Union Mutual Fire Insurance Company versus Michael Mahan and the Schwitzer firm, Supreme Court, Kings County.
Right. Union Mutual insured against a claim from the Schwitzer firm's clients, ceiling collapse case. But now the insurer is suing the lawyers who brought that case.
And our mission today is to really unpack the core legal fights here. Three big ones.
Okay, what are they?
First, does the complaint actually state a claim for attorney deceit? That's under Judiciary Law, Section 487. Big deal. Second, is there a claim for aiding and abetting fraud? And third, there's this huge defensive maneuver. Is the insurer's lawsuit itself an illegal SLAPP suit, aimed at silencing the other side?
Okay, let's start with that first one. Judiciary Law, Section 487, attorney deceit. Sounds heavy.
It is. It allows for treble damages, 3 times the actual damages. But the standard is incredibly high.
How high are we talking?
Courts call it egregious conduct, or maybe a chronic and extreme pattern of behavior. You can't just be, malpractice or using evidence that turns out faulty. It has to be intentional deceit aimed right at the court or the other party.
It's a penal statute, so liability isn't given lightly.
Exactly. They don't want every lawsuit lost turning into another lawsuit against the lawyers.
So what's the alleged deceit here? What's the insurer pointing to?
It centers almost entirely on the medical evidence from the client's surgeon, Dr. Alexios Apizidis. The insurer, Union Mutual, claims the Schwitzer firm knew this evidence was fraudulent, but used it anyway.
Knew it was fraudulent. How do they claim that?
Well, they point to patterns. They allege Dr. Apizidis used cookie-cutter language in operative reports. Same descriptions for different patients, just changing small details like, level, laterality, implant size.
Cookie cutter. Okay.
And they highlight specific inconsistencies. This is where it gets really detailed.
Give us an example.
Okay, so for one client, Mr. Toribio, the insurer says his MRI clearly showed a right-sided disc herniation. But the operative report from Dr. Apizidis, it apparently described removing a left-sided herniation.
Whoa. Left versus right. That's not a small detail.
Not at all. And there are others, like Apizidis supposedly claiming he did a follow-up visit that records show was actually done by another doctor, Dr. Lerman, or an operative report signed, get this, 2 minutes after the listed procedure time ended.
Okay, that sounds suspicious for the doctor. But how does that stick to the lawyers? Couldn't they just say, look, we relied on our client's chosen doctor?
That's the million-dollar question, isn't it? Proving the lawyers knew and intended to deceive. The insurer's aha moment, or what they claim is one, comes after they allegedly put the Schwitzer firm on notice about these problems repeatedly. Emails, calls, maybe.
They warned them.
Yes. And here's the really critical allegation for intent. The insurer claims that one lawyer, Mahan, actually indicated on a phone call he intended to withdraw from the case because of these issues, pending final approval.
Okay, so maybe he saw the red flags.
But then, allegedly, a higher-up at the firm named as John Doe Esquire, in the complaint overruled him, said, no, stay in the case.
So the argument is they knew it was bad, considered withdrawing, but then consciously decided to push forward with the suspect evidence anyway.
Precisely. The insurer frames it as the firm then proactively arguing in favor of the court's reliance on knowingly falsified evidence, specifically to defeat the insurer's motion for summary judgment. It wasn't just submitting a report anymore, it was allegedly championing false information they'd been warned about.
Okay, I see the argument. What's the defense say to that? How do they counter the Section 487 claim?
Their argument is basically, hold on, we didn't create these reports.
No.
They say they merely made use of his reports after the fact of their creation. They didn't conspire with the doctor to make them fraudulent in the first place.
So they're drawing a line between creating fraud and using evidence that might later be challenged.
Right. They frame it as simple advocacy. They're saying the insurer's just unhappy they couldn't easily discredit Dr. Apizidis and is trying to turn an evidence dispute into attorney fraud. Basically, you had your chance to impeach him, you tried, don't blame us now. It's a high bar, that's Section 487.
Okay, makes sense. So if Section 487 is too high a mountain to climb, what's the insurer's backup? You mentioned aiding and abetting fraud.
Yeah, that's the second cause of action. It still requires proving an underlying fraud occurred, but then you just need to show the attorneys provided substantial assistance to that fraud.
Substantial assistance. And what's the defense against that claim?
Here, the key defense is reliance. or rather, the lack of reliance.
How so?
To prove common law fraud, the victim generally has to show they justifiably relied on the false statement, right? The Schwitzer firm argues Union Mutual never relied on Dr. Epizidis' reports. They disputed them from the get-go.
That seems logical. They hired their own doctors for IMEs, independent medical exams.
Exactly. They filed a motion for summary judgment based on disagreeing with those reports. So the defense says, "Where's the reliance? You never believed us." They argue statements made in a contested adversarial lawsuit can't form the basis of a fraud claim precisely because the other side isn't expected to rely on them.
Okay, that sounds like a really strong argument for the defense.
Yeah.
How does the insurer possibly get around that? If they didn't rely, where's the fraud claim?
This is where the insurer gets creative, legally speaking. They argue reliance is broader than just, believing the lie.
Broader how?
They cite case law, a case called Artemis, apparently. And they argue that even if you don't believe the misrepresentation, if you're forced to spend significant money legal fees, expert costs just to disprove it, that expense itself constitutes justifiable reliance and damages. The cost of fighting the lie is the harm caused by the lie.
Wow. So they're saying, we wouldn't have had to spend all this money fighting your summary judgment motion if you hadn't used these allegedly fake reports. The legal fees are the damages resulting from the fraud.
That's exactly their argument. They claim their ongoing legal fees are the direct, proximate result of the misrepresentation. It's a novel way to frame damages in this kind of inter-party dispute.
That's quite a move. Okay, what about the substantial assistance part? Even if there was underlying fraud and reliance via costs, did the lawyers substantially assist it?
The insurer argues yes. They say actively presenting those reports to the court, arguing for their validity after being put on notice. That's more than just routine lawyering. They claim it crosses the line into active assistance, especially because the doctor, Epizidis, arguably needed the lawyers to keep the case going to potentially get paid through a lien on the settlement.
And the defense?
The defense says, no way. Performing normal legal tasks, like submitting your client's medical reports, that's not substantial assistance. They emphasize they had no fiduciary duty to Union Mutual, the opponent. Just submitting reports isn't enough, even if those reports are later questioned.
Okay, so it's a real clash over where advocacy ends and assistance in fraud begins.
Now, all this gets even more complicated, right? Because the defense has thrown up this massive shield, the anti-SLAPP argument.
Yes. SLAPP stands for Strategic Lawsuit Against Public Participation. New York has laws, CPLR, Section 3211G, and civil rights law, Section 76A, designed to stop lawsuits that are just meant to intimidate people or companies out of exercising their right to petition, like filing their own lawsuits.
So the Schwitzer firm is saying Union Mutual's lawsuit against them is just a tactic to shut down the original ceiling collapse case.
Pretty much. They call it a classic SLAPP. They argue it's leverage, a way to bully the firm into dropping the injured client's case. They even claim the insurer explicitly threatened them in an email, basically saying, drop the underlying case and we'll drop this lawsuit against you.
Drop the case and we'll leave you alone.
Wow.
That sounds like pretty direct evidence if true.
It does. And they point to other similar lawsuits by insurers against plaintiffs' firms as evidence of a bigger concerted plan. Okay, that seems powerful. How does the insurer fight back against the SLAPP claim? Because if it is a SLAPP, their case faces a much higher burden. Right?
A much higher burden. They'd have to show a substantial basis in law for their claims right at the outset, which is tough. But the insurer uses what they see as a loophole. The lawful conduct requirement.
Lawful conduct?
The anti-SLAPP statute is designed to protect lawful public participation. The insurer argues, we're alleging unlawful conduct here, attorney deceit under Section 487, which is also a misdemeanor, and fraud. Their point is, the SLAPP law doesn't protect the right to commit fraud on the court or engage in criminal deceit.
So you can't use the anti-SLAPP shield if you were breaking the law in the first place.
That's the essence of it. And it gets even more meta because the insurer points out that they warned the Schwitzer firm they would file their own SLAPP motion if the firm countersued them, just to stifle the insurer's right to pursue its claims.
Wait, both sides are threatening each other with SLAPP motions.
It seems so. It just shows how high the tensions are and how both sides see the other's actions as potentially crossing legal lines designed to protect legitimate court access.
This is really layers upon layers of legal strategy. So, moving towards the end of these arguments, how do the memos wrap things up?
Well, the defense really hammers the SLAPP point, They argue if the claims fail basic dismissal standards under CPLR Section 3211A7, failure to state a claim, they definitely can't meet the higher SLAPP threshold of substantial basis. They basically say the insurer shouldn't get a free pass for bringing what they see as a harassing lawsuit.
Okay. And the insurer's final punch.
The insurer goes for a clean hands argument, essentially questioning the Schwitzer firm's claim to be innocent victims of an insurer conspiracy.
Clean hands, how do they do that?
They bring in outside information. First, findings from the Workers' Compensation Board, the WCB, from April 2025. Apparently, the WCB found that Dr. Vadim Lerman, remember him, the associate of Dr. Pazidis.
Yeah, the one who did the follow-up visit.
Right. The WCB found he engaged in professional misconduct, negligence, and willfully made false reports related to patients in cases similar to this one.
So the insurer is saying, look, it's not just us saying there are problems with the medical providers you use. State boards are finding issues too.
Exactly. Trying to show a pattern, suggesting the firm maybe should have known better, or at least isn't being unfairly singled out. And then they drop some really explosive allegations.
Or what now?
They cite specific sworn testimony from the Schwitzer firm's own former employees and clients from other unrelated cases.
Okay. What kind of allegations are we talking about?
These are pretty extreme. The insurer's memo mentions sworn statements alleging mobster-like conduct.
Mobster-like? Seriously?
That's the term used. Allegations include things like a firm principal admitting to threatening an employee with vague references to actual mafia connections. Also, allegations of someone handing out cash from a briefcase to attract clients or case runners, and even staff members allegedly following claimants to try and dissuade them from testifying somewhere.
Wow. Okay, that's intense stuff to put in a legal filing about medical evidence.
It is, and it's clearly strategic. The insurer is using this to paint a picture of the firm, arguing they aren't just innocent lawyers being targeted by big insurance. They're arguing essentially that wrongful conduct related to this firm is being flagged by every aspect of the legal ecosystem, not just by them. It's an attempt to completely demolish the defense's victim narrative.
So wrapping this all up, what are the key takeaways, the main points of conflict here?
I think there are two huge ones. First, that massive gap between what counts as zealous, aggressive lawyering versus what meets that incredibly high egregious conduct standard for attorney deceit under Section 487. And second, this really interesting argument by the insurer about reliance and damages in fraud cases. Can the cost of fighting the alleged lie become the damage itself? If courts accept that theory more broadly, it could really change the dynamics in these kinds of disputes.
It's fascinating. This deep dive really shows the kind of trench warfare that can happen in litigation way beyond just the facts of the original injury. It becomes about the lawyers, the evidence integrity, the very process itself. So the question left for you, the listener, to think about is this. Where exactly is that line between pushing hard for your client and intentionally deceiving the court? And maybe more critically, should drawing that line, even when the allegations involve potential fraud or deceit, be constrained by anti-SLAPP laws designed to protect participation in the legal system?